there's my shoe. Okay, so I am train station. I have some time, forgive the bad angle, but I am going to go over, and I've mic'd myself, so hopefully you can all hear this well, but I've mic'd myself to go over the closing argument by Justin Brown, attorney for Adnan Syed. He started off, after thanking the judge for his patience a few too many times, he started off by saying very powerfully, "We believe in our case. I am proud to represent this man and stand beside him in his defense." He said that he was trying to sum up what has transpired in the last 4 days. He started off by saying it was a battle of two witnesses, and surprisingly, because usually when you say battle, attorneys refer to experts, but he was referring to very quote-unquote minor witnesses in the spectrum of this case, and that was the librarian versus Steve, and that whether security cameras were in place on that day. Now, she was 100% sure that because she was the person who was in charge of the video cassettes, she remembers 100% positive. There was no doubt, and that's in sharp contrast with Steve, who Brown did submit was quote-unquote telling the truth. He wasn't sure, but he was brave enough to admit his uncertainty. He wasn't sure if cameras were in the library at the time. He said, "I don't know," and he doesn't remember. So in essence, Brown summarized that part by saying the state's witness, Steve, ended up being, quote-unquote, a great witness for us. And it was emblematic of the case as a whole. Witnesses we put on are the ones who were known, and the state was trying, this was his theme, the state was trying to fit a square peg into a round hole. And he said that the state has a fine lawyer, and that Vignaraja was using a tremendous amount of force to force that square peg into that round hole, and that the state's position relied too heavily on speculation and that's quote-unquote crazy hypotheticals, including quote-unquote people on Mars and spaceships. What Justin Brown said, which I thought was great, was that the state, in essence, only put on two witnesses, and if you discount Steve, it's only one witness, and the only witness they put on was Fitzgerald. Okay, so then he moved on to the cell phone evidence, and he mentioned Abe Woronowitz, and that Abe Woronowitz said that if he had seen the fax cover sheet, he wouldn't have testified as he did in 1999. And I tweeted this out, but the court preferred the affidavit as opposed to Woronowitz testifying today. Woronowitz was in town yesterday. And in essence, this is according to Brown, Woronowitz, quote unquote, was recanting his testimony about the incoming phone calls, recanting his testimony about incoming phone calls. Okay, he also made a point of saying, okay, this is important, that the affidavits of Woronowitz, one was dated September 29, 2015, the other was October 5th, 2015, and that is when the defense was on notice. Okay, so this was important because it's not like the defense has known this since 2012 at the prior post-conviction, or that the defense knew this recently, but they've only been on notice since 2015. As to Agent Fitzgerald, quote-unquote, he wouldn't answer a single question I asked him unless it was helpful to the state. The truth is, there is just the bottom line that Justin Brown was saying is that both sides agreed that there was something wrong with incoming calls. Both experts agree, but each expert had a different explanation. Okay, the helicopter call. This was a huge problem, and the huge problem in that the defendant records indicate two calls, and one comes from Woodlawn High School, and then there's that 25 minutes later, it comes from DuPont Circle. It says there was something wrong with the incoming calls. The information in the report is wrong unless the defendant had a helicopter to get him to DuPont Circle. And then there was a lot of testimony. There were two problems with that. One is that I guess the theory is that Adnan Syed was in Glenmont, which I think is in Maryland. I don't even know, but even that's a 45-minute trip. So that's the first problem. And the second problem is that that the DuPont angle is inaccurate, and I'm assuming Brown means that both sides found this inaccurate. Okay, so it comes down to when Moranowitz took the stand in 2000, he did not understand what was going on. Quote unquote, they hung him out to dry and put him in a very, very awkward situation. That's what Brown said. And Brown said, as to Moranowitz today, he feels very bad. The cell phone was also important because of ineffective assistance of counsel. There was the state brought up this open file policy, but it's not 100% certain what Christina Gutierrez had access to. So referring to that document, which was discussed a lot about, I'm sure a lot of people tweeted about this, the one where the incoming calls is cut off, and then there's another section cut off. Justin Brown is saying that is the exact copy of what Christina Gutierrez had in her file. Okay, so moving on, then we're going on to Asia McClain. Basically that he said, he started off, some facts are stubborn, they don't go away, and we find out they're indelible. And the facts of Asia McClain have stood the test of time. Asia McClain saw Adnan Syed in the library on January 13th at precisely the time Hay is alleged to have been killed. We know that's the time because that's what Jay, the cooperating witness, testified to. And the timeline established at trial is the timeline. And this was a question asked on Twitter if the timeline could change. And I think it was a good point that, no, the timeline can change. Timeline is the timeline. Then Justin Brown pointed out the note in the file, an affidavit signed by the law clerk Ali. This was very important because that was that July 13th, 1999 note that said about Asia McClain. So if Christina Gutierrez got the case in April and this note was in July, we can assume that she was on notice of Asia between April and July of 1999. No one from the Gutierrez team spoke with Asia, and that includes the clerks as well as the investigators. That Asia McClain didn't testify at trial. Sorry, they're just making that point. He says a mistake was made because the mistake not to talk to an alibi witness who could have turned this trial around. Walking in her footsteps. This isn't powerful. Justin Brown talks about walking in Christina Gutierrez's footsteps for the last 7 years. He says, yes, she wanted to win. She tried to win. She was a fighter, but there was something there was something wrong. There was way too many signals, and there was way too many red flags. And Justin Brown kept hitting home with that, and he spoke in a very sincere way about that. He spoke about the witnesses, Dantes and Cabashir, who spoke about Christina Gutierrez's problems. He said about when your health declines, you lose a step, and then things pile up. By the time Gutierrez tried this case in 2000, she was not operating at full strength. She was sick, and 4 years later, she passed away. It was very sad. State's going to argue that the attorney was organized, her top of her game, ducks lined up. All right, we're going to talk about the state later. Anyway, and that Dave Irwin, the expert, looked through Christina's file and found that it was disorganized. There was lots of to-do lists, but maybe things not done. And in essence, Irwin said that Asia McClain, the diamond, slipped through the cracks. Okay, I'm looking for, all right. So then he goes on to talk about the case law, and I'll probably tweet out like a list of cases if people are interested in looking at them. You cannot okay, give me 1 second. You cannot, okay, so the case law is clear. You cannot conjure up a strategic reason for not contacting an alibi witness. You can't speculate about it. There has got to be a real reason. Otherwise, it's just a guess. There's this myth that Mr. Syed gave a statement to the police officers that contradicts Adnan, Asia. And he refers to this quote from the transcript by Officer Joseph O'Shea, January 31st, 2000, that there was something contradictory about what O'Shea testified to and what the timeline was, but he said there's no contradiction. This was unclear. It's very hard to follow unless you knew exactly what was going on prior to the hearing. The second myth, that because Christina Gutierrez filed alibi, she had no duty to contact Asia McClain. She knew about Asia McClain latest in July. There is no new theories to try and excuse Gutierrez for not contacting Asia McClain. And they put in the Joanne Gordon affidavit to contradict the people's theory that there was something sneaky going on in terms of witness tampering. This is Justin Brown's bottom line, is that the state didn't prove anything. It would have been nice to hear from someone who could prove their theory, but they only called 2 witnesses. It is well established that a refusal to investigate a witness that has potential exculpatory evidence is basically, the cases say that could be ineffective assistance of counsel. He mentions a bunch of cases. Let's see, Lopez versus Miller, Inri Harris W, Griffin v. Warden. I can't read my handwriting. Brown v. Salome. 8th Circuit cases, 4th Circuit cases, 2nd Circuit cases. Another case, Pavel, Pavel, 2nd Circuit, Lawrence versus Armitow. I don't know what circuit. Pena Martin versus Duncan, 2nd Circuit. Poindexter versus Booker, 6th Circuit. And Justin Brown said I could go on and on and on, but in total, there are at least 70 cases that say the defense attorney must interview and investigate an alibi witness before making a strategic decision. That's what Strickland is all about. And Strickland is the United States Supreme Court case that controls. And then he went on to talk about prejudice, and that things got a little confusing. And basically he was saying that Adnan Syed was prejudiced by not calling Asia, and in prejudice he means he was harmed. So it's different. It's not racial prejudice. Someone was asking me that today. It is, was the defendant harmed? And that an alibi is the best defense, according to Dave Irwin, that it was prejudicial because if the defendant was at the library with Asia, he couldn't have killed Hay. The law says the witness... Okay, this is important. While a witness doesn't have to be perfect, they just have to be good enough. And that's the law on prejudice. That's the standard. Strickland says a defendant need not show that that the defendant's conduct... I'm sorry. Okay, this is a little much. So basically that the standard is a reasonable probability the outcome of a trial was influenced by counsel's errors. Reasonable probability outcome of trial was influenced by counsel's errors. That is ineffective assistance of counsel. He says Asia was earnest, honest, credible. Everyone agrees with that. How do we know that she's being truthful? Because she talked about the security cameras. She told us that her boyfriend was jealous. The school was closed the next days. She took notes when talking to Kevin Urich, her calm demeanor, and that she had that purple pass from 17 years ago. So all these little details is how we know she's being truthful. She didn't know that I think this was a huge important thing, is that Asia McClain never knew until, 2014, that she was significant, that it was the time. That the time was significant. quote unquote, she does not have a dog in this fight. I thought that was powerful when Justin said that she was a fantastic witness, and that Irwin said, quote unquote, quote, Justin, his whole career he's been looking for his Asia McClain, because Justin, quote, she very well could have changed the outcome of the case. And let's see, I'm going to be wrapping this up. Let's see. Okay, so he ended basically that no defense attorney can defend. Oh, this was good. No defense attorney can defend not contacting an alibi witness. Okay, this is the end. We proved our case. We put on corroborating evidence to their claims, cell phone evidence and Asia McClain. We did exactly what we said we were going to do. Adnan Syed deserves a new trial. Okay, I'm going to get on the train. I'll talk to you guys later.
Thank you for choosing Amtrak.